The summary plan description is there to provide plan participants, beneficiaries, with information about benefits. When we use the word participants and beneficiaries, or specifically beneficiaries, when we're talking about group health insurance, we're talking about the dependents that the participant has enrolled in the plan. So it gives them information about their benefits. It also notifies them of their ERISA rights and responsibilities. ERISA is a law that governs health plans. It's been around since 1974, and it does have some of the legalities of offering coverage and what the responsibilities are. The time frame for distributing this little booklet, or this book description, whatever you want to call it, is within 90 days after the plan coverage begins. One thing that I want to point out is that you get a little booklet probably from your health insurance carrier that you can give out to your employees, or you get something that they can refer to online. There are specific rules that you have to follow about having this online, but we're going to talk about that later in the presentation. Right now I want to tell you what this is not. It's not the little booklet that you get from the insurance company that has a description of your benefits in it. It is something that is more comprehensive than that. I'm going to say back in the old days, the insurance companies, health insurance companies, used to give out booklets that had ERISA rights and responsibilities in the back of the book. And they stopped doing that because they did not want the liability of having to defend their language in that book, because it's actually supposed to come from the employer, from the plan. So if you have a little booklet that you get from the carrier that tells your employees this is when they can enroll, this is when this is what this covers, etc. Other things that have to be in that little booklet for it to be a summary plan description include your plan number. That's not your contract number, it's actually a plan number assigned to your plan. It has to have in there what the person's, if they have a complaint, who do they report it to? And that's specific to your company. So it would have a name of a person, it would have your address and phone number or email address. So it's very specific information in there. And after this webinar is over, I'd like for you to go back and look to see if the booklets that you're handing out or the information that you hand out to your employees actually has that section called ERISA rights and responsibilities. If you do, good for you. If you don't, it means that you don't have a summary plan description. And a summary plan description is required for every single benefit plan that you offer. Your health insurance, your dental insurance, your life insurance, your disability insurance, all of those are protected under ERISA and require that a summary plan description be given to the participant within 90 days after that plan coverage begins. This is the first thing that auditors ask for when they come in the door, is to see a copy of your summary plan description. So that's the first obstacle. It is on their list of things to check. So if you do experience a Department of Labor audit, that will be the first thing that they ask you for. Once you get this in place, let me back up. If you can't find yours or don't know if you have one and you want to talk about it, please call me or email me. I'll be happy to help you decide if what you have is a summary plan description or not. The requirement under the law is that you change this document or update it every 5 years if you have changes or amendments that come into play during that 5-year period. However, if you don't have any changes, you only have to update it every 10 years. So once you get it, if there are no changes, then you're fine. Normally, though, we change our health plans every year. If you're like us, we change either the coverage or the company that is providing the coverage, or something about it changes. So you would need to provide a new document every time you change carriers, obviously, because the contact information is different. So the summary plan description is very important. It is the first document that the auditors asked for, and I want you, after the webinar is over, to make sure you go back and see if you can pull your summary plan descriptions for each of your plans and make sure you have a copy in your office. So as I mentioned, it's the first item requested in an audit. Then there's the summary of benefits coverage. This came out under the Affordable Health Care Act, HCA, and it is a summary of the benefits and coverage under the health plan. It provides an overview of the health plan benefits being offered, and it's displayed in a grid format specified by the Department of Health and Human Services, DHHS. That's the abbreviation for that department of the federal government. And they are the ones that control HIPAA and some of the other medical programs like Medicare and Medicaid. This document explains the terms commonly used in health insurance coverage, and it provides examples of how claims are paid. The purpose of this was to allow people to be able to compare one plan against the other by having a uniform layout. They even determine what font you can use in this particular document. So the employees that are being hired need to be given a copy of this with their new hire benefit package if they are eligible for your benefit plans. You do not have to give it to part-time people or people who are not eligible for your plan. Then every year it's to be given to eligible employees at open enrollment, and these are all requirements under the law. This is what it looks like, the summary benefits coverage. So you may be familiar with this. It's always blue and white for some reason, or I've never seen one that's another color, but it does go over what's the deductible, what is the coverage under the plan, and that's just, I'm sorry, let me go back to that here. Basically the layout of the plan, and this is about 4 pages long, double-sided, so it is extensive, and it goes over your plan specifics. So that's what that one looks like. The Notice of Health Insurance Marketplace Coverage Options is sometimes called the Exchange Notice. It informs employees of the existence of the marketplace and how to contact the marketplace for assistance in finding healthcare options. The marketplace is what came about under the Affordable Care Act, where you can go online and purchase insurance on your own if you wanted to. This is also a place that people who are not employed go out and find their coverage. Under this notice requirement, there are 2 model notices for employers to use. One is for those who offer health care to their employees, and the other one is a model notice for those who do not offer health care to their employees. So this is just health care, and it's going to give employees information about your plan and also about where they can go to look for health care if they don't want your coverage. It has to be given to all current employees during open enrollment each year, and every single new hire that goes on your payroll, even if they're not eligible. So that would mean part-time people, temporary people would be given a copy of this notice when they are hired. The model notice, and I've given you the location here, can be found on the Department of Labor's website at this location. So those model notices are there. You can pull them off and just make them your own and send them out. It could be something you just keep on file because it has your information on it, along with whether or not you offer coverage. And I will be posting this so that you have access to these website addresses. The notice of special enrollment rights is required under HIPAA, which is the Health Insurance Portability Act. This describes the plan's special enrollment rules, which is the eligibility to enroll dependent children outside of open enrollment. Has to be given to an employee when they're enrolling in the health plan. And it may be included in your summary plan description. The things that we've talked about so far, the summary of summary plan description, summary of benefit coverage, those have to be given to the employee outside of your, your SBC, which is your summary of benefit coverage, and the exchange notice have to be given outside of the summary plan description or the booklet that comes out with your health insurance renewals each year. Sometimes these notices, and I'll point these out, this one in particular will be included normally in that packet of information that you get from your health insurance carrier that tells you where you would get this information about special enrollment rights. So it's a notice that goes out each year during open enrollment. The model notice, if you're looking for one, and it's not included in the information that your broker gives you or your insurance company gives you, you can find the notice at this location. The disclosure of grandfathered plan status. When the Affordable Care came out, some plans were grandfathered, and that meant that you could keep your same plan and plan design. The rates might go up, but the status of it would stay the same as far as what your benefits were. There are just a very few of these plans left out there, but if you do still have a grandfathered plan, you need to notify your participant that your plan is grandfathered each year, and that would be done at open enrollment and when the person first enrolls in the plan. This would not be a part of whatever your insurance company gives you usually. It is a separate notice. Here again is where you can locate the model notice for this. Anytime you use a model notice, the Department of Labor will not look any further than the notice if you're using that, because some people create their own and that creates problems for you because it may not match up to the requirements of the Department of Labor. So it's best to use the model notice whenever possible. The Women's Health and Cancer Rights Act notice is something that you have to give out annually, and it does not come in your booklets. It is required to be sent out by the employer once a year, and it requires, it describes the required benefits under the law regarding breast reconstruction following a mastectomy. And this is one of the very few that has to be distributed by the employer annually to participants in the plan. It's listed as an item on the Department of Labor audit worksheet, and so you need to be able to prove that you sent this out to all of your plan participants. So what you can do is I suggest you make a list of all the employees that you're sending it to, put on there the date that you sent it out, and and that's all you have to do is drop it in the file. That would prove that you sent that out. If you do it during open enrollment of each year, which is the best time to probably do this, you won't have to have a separate mailing. That makes it a little bit easier for you to remember it too, but it usually is not included in your information that the insurance company gives you. So if it is, that's great, but make sure you check, because this is one that you have to be able to prove you sent it out. And there is again a model notice for this on the Department of Labor's website. The notice of the employer, CHIP, and that's an abbreviation. It's the Basically, this notice provides information about opportunities for premium assistance in your state under Medicaid and the Children's Health Insurance Program. Each state has its own program, but it's called CHIP, C-H-I-P, Children's Health Insurance Program. This is something that you have to give out annually. I would do it at open enrollment. Check to see if it's in your insurance packet that you get to hand out to employees. If it's not, you need to make sure that you do it, because it is something that you will have to prove that you sent out. This one has to be given to all employees, not just those people who are participating in your plan, but anyone that's eligible to participate in your benefit plans, so that they know that they may have assistance with the premium that you charge for health insurance under the state laws. Model notice is available at the Department of Labor's website. These are all at different places, so I couldn't just give you one place to look. They're each in a different spot. The next notice is the Medicare Part D Notice of Creditable Coverage Disclosure. This is really important too, but it doesn't impact as many people. This provides Medicare eligible employees and their spouses and or disabled dependents and retirees information about whether or not prescription drug coverage that you're offering as an employer is considered creditable. Creditable coverage is coverage that's as good as what Medicare offers to Medicare participants. Your insurance company can tell you whether your coverage, your prescription drug coverage is creditable. And if you don't know, you need to ask them. There are two model notices available. One for creditable coverage. That means you have coverage that is equal to or better than the Medicare coverage that's offered for prescription drugs. And then one for coverage that's not creditable. The reason that this is important is that if a person who is eligible for Medicare signs up for your plan instead of Medicare, and your prescription drug coverage is not creditable, then they will pay a penalty later on when they decide to get the Medicare prescription drug plan. They'll pay a penalty for not enrolling in it at the time it was offered to them. If you have an HSA plan, there's a good chance that your prescription drug program is not creditable. So if you want more information about this, please let me know. This applies to those individuals who are eligible, Medicare eligible age. It has to be distributed by October the 15th of each year. And I suggest that you send it to everyone, only because unless your population is small and you have a good handle on who their dependents are, if they have a disabled dependent, that dependent may be Medicare eligible regardless of their age. But generally, someone would be eligible for Medicare Part A when they are 65 years old. So you can just send it to those who are 65 and anyone that might be on Medicare from a benefit standpoint for a disability claim. HIPAA has a notice called the Privacy Practices for Protected Health Information. This describes ways that your personal health information may be used and disclosed, patient rights, and the plan's duties to protect information. I would bet this is in all of your insurance booklet materials, but please check because it is something that needs to be sent out annually to those who enroll in the health plan, because it does tell them how the plan treats their health information. It usually is included in the summary plan description or the benefit booklet that you give to your employees. And basically include this with the materials that go out during open enrollment. COBRA. You may have someone on the outside, an third party doing your COBRA, but this general COBRA rights notice, it's also called an initial notice, tells the individual of their right to continue benefits after coverage is lost due to a qualifying event. It also tells the participant there's a requirement for them to notify the plan administrator, which is you, of certain changes, like when they get married, divorced, they change their address, they have a baby or adopt a child, and it outlines the time frames for those notices. I call this your get out of jail free card, and I only do that because if you don't send this notice out, or you can't prove that you sent this notice out, then someone could come back to you. I'll give you an example. Someone could have a baby and wait 90 days to tell you. Well, in your under your general COBRA rights notice and in your summary plan description and all your insurance materials, it tells them that they have 30 days to notify you, and they waited 90. So they can't add the baby to the plan. And that provides a problem because they have a birth, the child was born, they have expenses there for the nursery, etc. So this person could file a charge that you're refusing to cover their child, and they would file a charge, and you would go back and say, well, we told them that they were required to tell us within 30 days because that's what our insurance company requires. And they tell the court that, or their attorney, that you never notified them of the 30-day time frame. That 30-day time frame is in this general COBRA rights notice. And if you can prove you sent it to them, then you are home free. You're getting out of jail free. Otherwise, if you can't prove that you sent it, then the ball is back in your court. And insurance companies aren't very flexible about retroactively adding people 90 days or 6 months later after the fact. What could end up happening, and happens in most cases, is that you as the employer end up paying the claims of that child and putting them on your plan as soon as possible. But the claims for their birth and anything else that's happened in that time frame would be paid out of pocket by the employer. And that wouldn't be something fun to communicate to upper management, that it didn't happen. COBRA law indicates that this notice should be handled by first-class mail when they first enroll. So if you have an outside third party administering your plan, make sure that they are sending this notice out for any new hires that you send over. Bottom line, COBRA is always the responsibility of the employer, regardless who handles it. You can't assign responsibility to a third party. So if there's a lawsuit or a charge, they will come to you for the claim. You do have to send it to their home address, though. So you can't just hand it to them. You can't put it in their paperwork when they enroll. Here is a model notice for you, and that'll be available to you later. But this is a very, very important notice that a lot of employers don't remember to send out, and if they do send it, they don't track it. You do need to be able to prove this. This will shut the claim down immediately if you can prove that you sent this notice out. So put this high on your list for compliance. Summary of material modification. If you do not have more than 100 people, you're probably not going to run into this. This normally comes about for retirement plans, but retirement plans have summary of material modification, which means it outlines any changes made to the health plan or any of the other plans that you have from the prior year. You'll generally see this more frequently with retirement plans. But you need to give this to each covered participant within 60 days after you adopt a change in your plan. And it would be a significant plan. Or plan change, excuse me. This is provided by the insurance company, and normally it comes in the form of a new booklet every year. We don't hand out paper as much as we used to, so that's why it's important to make sure that your employees have access to this information on an annual basis. The summary annual report is also something that you'll see more frequently with retirement plans, but it's only required for plans with more than 100 participants. Generally, you'll see these for self-insured plans and retirement plans. It summarizes the financial information of the plan for the prior year, and it's normally provided by the carrier or the insurance company or the sponsor of the or record keeper for the retirement plan. Okay, let's talk about how you can distribute these notices. That was a mouthful, wasn't it? Lots and lots of notices. But how can you distribute these notices? You can do it by regular mail, and you can do it electronically if you follow the rules. So if most of the employees or the majority of the employees in your company use a computer in the course of performing their job, then the documents can be distributed to them without prior consent by the participant electronically. Okay, so if you have a manufacturing company and the people in the plant don't use a computer, but the people in the office do, that would mean that you could not just across the board, say that you can deliver these electronically, because you have to have prior consent by the participant. So for participants who do not use a computer at work, they have to, and if you decide you're going to do this electronically, and let's say 50% of your people are in the plant, 50% are in the office, you're probably going to want to follow the same rule for both groups. So if you want to send it electronically, you're going to have to get all the participants to consent in writing to receiving the information by email, for example, or going to a website. You need to provide an email address and instructions on how to change that. I'm sorry, they need to provide an email address to you and instructions on how to change that email if they need to do that. They need to be informed about the procedures to withdraw consent or to update that information. Also, they need to be advised that they can receive a paper copy and be told what delivery system will be used and what software it will require. That's a lot, and that means that this is another thing as an HR person or someone who works in the office or a payroll person, another thing you have to track, and we track a lot of things. So a lot of companies still deal with paper unless they have an employee base that sits at their desk all day long and works on a computer. If that is the case, then you're home free. It's just when someone doesn't have access to a computer during their normal daily work. This does not include a kiosk in the middle of the lunchroom. Unless they have to punch in and out from a time clock perspective, they have to punch in and out on that kiosk, and they can pick up other information at the same time. If you have a specific situation that you'd like to talk about, please email me after this, and we can look at how your information can be disseminated. So this is one thing I think that some employers, the rules they aren't following, because we just post everything on the website, or we give them a benefits card and we say go to this company's website if you want more information. And that's not really the way you're supposed to do this, because if they don't have access to a computer, they can't go to that website. So your action plan, first of all, review your notices. Pull out everything that we've talked about today and see what's missing. Then, obviously, whatever you don't have, you're going to need to find it or go to your carrier for it or go to your insurance broker. I would ask my broker if I were you, your insurance broker, because they're supposed to help you with things like that. They get paid to not just sell you insurance, but to service it. Then gather all the missing notices and determine the method you're going to use for distribution. Is it going to be electronic, or is it going to be first-class mail, or having them walk in your door and sign for it? You want to make sure you can prove that you gave them this information. And then create a calendar for distribution of notices. Remember, I said that if it's in your summary plan description or the booklet that they hand out at open enrollment, then you can use that as for most of these. But for example, the CHIP notice and the Medicare Part D notice and the Women's Health and Cancer Rights Act notice, you cannot use it for that. Okay, I'm going to open up the chat and see if anyone has a question. Okay, let's see. Sandy has a question. So if all the COBRA information is included in the summary booklet we give out, will that not qualify? Technically, under the law, it's supposed to be sent out first-class mail because the family members that enroll won't get it. So I know that a lot of companies do this, but it is required to be sent by first-class mail. Another question, if all these notices are included in our summary booklet, will that be sufficient, or do we still have to send individual notices? You have to do it. Most of them can be included in your summary plan description. The summary of benefit coverage, the blue and white grid that I showed you, that has to be given out to employees with the materials that you hand out in open enrollment each year because it normally changes. The CHIP notice and the Medicare Part D notice and the Women's Healthcare Rights notice have to be given out annually, separate from the SPD. Okay, Rebecca has a question. Is this webinar recorded for us to view later? Yes, it is. And another question, what if notices sent by mail are returned because the address is no good? That's a very good question, even under COBRA notices. If that is the last address that the employee gave you, and that's the last known address you have in file, then it just put the returned envelope into the person's file, and that's all you're required to do. Now, if it's a COBRA notice for a new employee and they've given you a bad address, obviously you're going to want to straighten that out before you go any further because they're brand new. But COBRA notices or any other notices sent by mail that are returned, just put it in their file. Howie has a question, have government entities actually, actually fined employers for non-compliance? Yes, they have. There are significant penalties if you're audited. If you don't have a summary plan description, they'll give you time to go get one, but they are going to look at the other notices and see that if you've sent them out. And yes, they have fined employers for non-compliance. Sandy has a question, the grid and all the notices are included in our booklet. Does that mean the COBRA is the only one that has to go separately? We give it to each new hire, and when open enrollment comes up, a new booklet is given to all. As I mentioned, the Women's Health Care and Cancer Rights Act, if you make sure that each person has that every year, regardless of where you put it, that's fine. The COBRA initial notification or general notice generally does have to be mailed. And the others can be included in the booklet if you have some way of tracking that you gave it to them. The Medicare Part D notice is not normally put in. It can be in your booklet, but it's normally sent out as a separate notice. Also, the CHIP notice, because that's given to all eligible participants when they're hired and not after they enroll. So it's given to people who have them be able to determine if they can afford the coverage. Okay, any other questions? Thank you very much for your time today. I appreciate the time you take out of your day to listen to this, and I am here to answer any other questions that you have. This PowerPoint will be available by tomorrow. It takes about 24 hours for it to download, and we will have it posted for you. And if you want a specific copy of the PowerPoint itself, just shoot me an email and I will send you a copy of this. Thanks for coming today, and I look forward to having you at our next session, which will be in 2 weeks, and it is going to be on workplace harassment. So in the meantime, let me know how I can help. Thank you.